applications. And we've got Gary Greenberg and Stephen Lazarus, which is the perfect duo for this. They've done a traveling road show across the state. They've already done a couple of events together, so this is not their first rodeo. And of course, what we're most interested in is, irrespective of the election results, what are those legal and policy implications? What can we expect, you know, both philosophically, economically, and then also as practitioners to run into how does this change labor law, and what does it mean in negotiations, in management labor negotiations for public sector collective bargaining. So, of course, my name is Maurice Thompson, the president of the Federalist Society this year. First time I've been up here since we had one of these events. Before I introduce Gary and Stephen, I just want to briefly run through a few of the items that are actually in Senate Bill 5. You know, we think of it as this big monolith, and we know some of the things that are in it. I went through the referendum petition a while back, and then consulted that again today, and just want to point out what I think are probably the 10 or 12 most salient provisions. This is from the actual referendum petition filed, so I'm not shading anything when I describe these issues. And then, of course, Gary and Stephen may have some other issues they think are more important than these and want to reference, but this will at least allow them to kind of skip the steps of having to explain to you what's in the bill before they can dig right in. Senate Bill 5 expands the list of subjects that are inappropriate for collective bargaining. It prohibits public employees from striking. It expands the list of factors a fact finder must consider in resolving disputes, and requires the fact finder to consider as the primary factor the interest and welfare of the public and the ability of the public employer to finance and administer the issues proposed. It eliminates statutory salary schedules and steps. These are the step increases that have been very much discussed. Requires performance-based pay for most public employees, including board and commission members. Requires performance-based pay for teachers, as we all know. Caps vacation leave. It reduces sick leave for public employees. And amongst all of the issues here, my other star points were: it prohibits a collective bargaining agreement from prohibiting a public employer that is in a state of fiscal emergency from serving a written notice to terminate, modify, or negotiate the agreement. That's awfully, seems like it could be awfully significant. Prohibits an agreement from containing a provision that requires a condition of employment, as a condition of employment, that non-members pay fair share fees, so essentially a right to work provision in SB 5, and prohibits a collective bargaining agreement entered into or renewed on or after the bill's effective date from containing provisions limiting a public employer's ability to privatize operations. Seems like it could also be very significant. Limits public employer contributions to both healthcare and pensions. Abolishes continuing contracts for teachers, which is essentially tenure, and prohibits public employers from paying employee contributions to the 5 public employee retirement systems through pickups. And of course, there's the one thing that's not mentioned here, the automatic payroll deduction that was tacked on by the House and then approved by the Senate, which requires that employees actively opt into political contributions instead of just opting out. So with that in mind, let me introduce Gary and Stephen to debate these issues. Gary will spend 15 minutes discussing, Stephen will follow up with 15, and then they'll each have a few minutes to address each other's points, at which point we'll have a few questions from you. Of course, we've got this videotape today. We've got a new website for the Federal Society chapter we'll be rolling out, and so we'll try to cover more of these events as we do them throughout the season. Gary is principal at Dellinger, Rosenthal, and Greenberg. Has devoted his career to practicing management side labor and employment law. He's a member of the Federal Society and the Ohio Management Lawyers Association, and he's also helped advise the Ohio Liberty Council and the Cincinnati Tea Party groups on some important labor policy issues. And then Mr. Lazarus is a principal in law firm Hardin, Lazarus, and Lewis. He's focused his practice area on the representation of public safety employees and their unions. He's lectured on civil service law, arbitration advocacy, and negotiation strategy throughout Ohio. So we have two gentlemen here who have represented both management and labor only, as far as I know, respectively, at the negotiating table in the public sector, so they can talk about those experiences, how this bill affects those experiences. So with that, Mr. Greenberg.
Well, I appreciate that. It must be because I'm a fellow member of the Federalist Society. I want to clarify a couple of things about our firm's work. About 80 to 85% of our work is in the private sector, representing employers in labor and employment law. That includes labor negotiations and union-related matters, but also other employment-related issues, EEO and wrongful discharge, and so on and so forth. In the public sector, we represent a number of municipalities and townships in labor relations. We've represented a few county agencies over the years, one joint vocational district, but mostly municipalities dealing with their police unions, their firefighter unions, their blue-collar and white-collar unions. So when I agreed to come up here and speak to you this evening, Maurice emailed me and he said that I should limit my focus on politics, because you've heard a lot about the politics of all of this for several months now, and focus more on the practical and legal issues. And I will focus on the practical and legal issues, but you really can't separate those practical and legal issues from politics. In the public sector, the person that you're negotiating with one day representing the city could the following year be the mayor. And of course, day in and day out, unions wield a tremendous amount of political influence over the people who give me direction, give us direction at the bargaining table, the legislatures and the elected representatives. On the non-public safety side, that's those unions mostly wield influence with the Democratic Party. On the public safety side, the police and firefighter unions wield quite a bit of influence with both political parties. And so that's just the reality that we deal with in representing public employers. So let's step back for a minute and talk about collective bargaining reform in the larger context of the state of Ohio. And let's face it, Ohio, the great state of Ohio, is not what it used to be. The state that gave us the airplane, the business machine, the automatic ignition, rubber tires, etc. A state that's known for progress and innovation and productivity has fallen on hard times. USA Today did a study, or perhaps they used somebody else's study, but they had a front page article a couple of months ago which they listed all 50 states and the gross domestic product of the 50 states in order today versus 10 years ago. And one of the things that was noteworthy is how the state of Texas kind of shot up on that list, and that's very interesting. But I don't really like to compare Ohio to Texas. I think that's apples and oranges. But I do compare Ohio to Indiana, two very similar states that have, I think, taken different directions. When you look at this list, you look at this article, you see that of the 50 states from 2000 to 2010, there are only 2 that did not have an increase in GDP. That's Ohio, which was basically flat for that 10-year period, and Michigan, which, not surprisingly, actually lost GDP during that period of time. On the other hand, our next door neighbor, Indiana, increased by 10%. During that period. Not dramatic, but significant. And I think there are a variety of reasons for that. But I think one of the most important reasons that Indiana has made so much more progress than Ohio is that Indiana is a more welcoming and friendly place to do business. And so that when businesses are deciding If they're going to locate in the Midwest, they're going to locate in Indiana rather than Ohio. We saw that, for example, with the new Honda plant, which went to Greensburg, Indiana, rather than a place where it was already doing business near Columbus. So what does all that have to do with collective bargaining reform? Well, when we look at the problems with the federal budget, personnel costs at the federal level are really a pretty minor part of the picture, minor part of the problem or the challenge. The major challenge at the federal level are the entitlement programs and transfer payments. But at the state and local level, what you'll find is that the major budget challenge is with personnel costs. And personnel costs in the state of Ohio, from my point of view, have been eating this state alive. And what we've seen over the last 10 years is with GDP flat, with earnings among private sector employees flat, what we've seen in the public sector with government employees is a ratcheting upward. Year after year after year, those costs have been going up, whereas the earnings and the GDP in the state have been flat. And so what does that mean? I mean, how is that paid for? Well, it can only be paid for in one of two ways: through tax increases or cuts in services. So what Governor Kasich and the state legislature tried to do with SB 5 is to reform collective bargaining, to frankly change the balance of power, balance of leverage at the bargaining table to ratchet back these ever-increasing personnel costs so that we can continue to provide decent public services that we all agree, or most of us agree, should be provided through the public sector at a reasonable cost. So let's talk about the nuts and bolts of how it works under the current system, how it would work under SB 5, or what's now called Issue 2, and what might happen after the election if SB 5 is eliminated. And frankly, based on the polling that we see today, it seems more likely than not that that's going to happen, although one never knows who's going to turn out on Election Day and how they're actually going to vote. The handout that I've given you deals with the nuts and bolts of the current system and what Issue 2, what SB 5 does or tries to do. And of course, I've written this from my point of view, that it's to urge people to vote yes on Issue 2, but I believe it's also an accurate description of the current system and what collective bargaining reform would do for us, for the citizens and taxpayers of Ohio, if it remains in place. So let's start with the big picture. State and local government employees can be divided up into two types. Actually, three types. There are a handful of state and local government employees that currently do not have the right to collectively bargain or to join unions. But most do. And I think most have over the last 25 or so years since government employees were given collective bargaining power by the state legislature back in the early 1980s. So the unionized employees of Ohio are divided into two types: public safety and non-public safety. And there are some important variations, differences between these two groups. The public safety employees, of course, are the police, the firefighters, corrections officers, sheriff's deputies, and state troopers. I think I've listed almost all of the categories that fall under public safety. And so because of the danger to public safety that would result from strikes by these employees, the state legislature did not give them the right to strike, unlike the power to strike that was given to all other unionized state and local employees. Instead, a system was set up for the safety employees and their unions that is called conciliation. But conciliation is really I would say, a euphemism for binding arbitration. So to put it in the simplest possible terms for you, what it comes down to is this. If I'm representing the city of Cincinnati, I don't represent Cincinnati, so I'm going to use it as an example. If I'm negotiating with the Fraternal Order of Police for the patrol officers in Cincinnati, and the city decides that it wants to offer 1% across-the-board increase each of the next 2 years for a 2-year contract, and the police demand 3%, and we can't come to agreement, we're at 1%, they're at 3%, there are a number of steps that have to be followed after that. I won't bore you with those, I want to cut to the chase. If after following all these steps we're still at 1% and 3%, a third-party arbitrator is hired who can live anywhere in the state of Ohio. So he could be somebody who comes down from Dublin, Ohio, to tell us down in Cincinnati what we're going to pay our police. And we have a hearing, and we present evidence about what these police officers do and what they ought to be paid based on, usually it's based on statistics comparing them to other arguably similar police forces around the state. And after this evidence is presented and briefs are filed, the arbitrator makes a decision. 3% or 1%. And if he says that it should be 3% for each of the next 2 years, that's it. There's no recourse to a court or to any higher authority. It's a done deal. And if that 3% eats into the city budget and requires cuts elsewhere, so be it. Or if it requires a tax increase to pay for it, so be it. Has to be done. Now, if you read the statute, there is a suggestion of a right of appeal into the court system, but that is for extreme cases. I mean, really, as a practical matter, there's no appeal. Obviously, if you could prove that the arbitrator was bribed or intoxicated, then perhaps you'd have recourse then. But otherwise, it's done. This is imposed on the city, and those raises then go into the next 2-year contract, and they're paid. And the city has to find a way to pay them. So what would collective bargaining reform do with the system? It would return to our elected representatives the authority to make the final decision. So if we have the same negotiation where we reach impasse and the police union demands 3% and city management proposes 1%, there's a hearing before city council, each side presents their arguments, city council makes a decision. Now you'll hear my esteemed colleague refer to this as collective begging or just a roundabout way of eliminating collective bargaining altogether. I beg to differ. Let's talk about political reality again. Remember what I said about the influence that unions have over the political process. That influence would still be there. What we have now is essentially this. The unions in the state of Ohio have 2 huge bites at the apple to get what they want. One is their political influence, where they let their political leaders know, our political leaders know what they want, and that they'll be very unhappy if they don't get it. And we all know that for somebody running for city council or mayor, an FOP or an IAFF endorsement is important and useful. So, so the political influence is there today, and it can be effective. You'll hear my colleagues say that very few of these issues go to arbitration. That most contracts are settled without going to arbitration. But remember, keep in mind the political influence I mentioned and the fact that arbitration is always hanging over your head. So it's, you know, let me tell you something about the process as a practical matter. A union can say, and they do, that you know, we might be able to work this deal out at 2.5%, but if you're not going to go that far, then we're just going to hold firm at 3%, and we go to arbitration, you might find yourself with 3%. So do you want to give us the 2.5% today, or take the risk that an arbitrator is going to impose 3% on you? All right, so that's the way the current system works. The new system will city, township, and county, and state legislatures back their negotiators in many cases? Yeah, I suspect so. And frankly, that's the way it should be. Because these are our tax dollars, these are services for us, provided to us, and it's my sincere and firm belief that you know, that democracy is the solution. Democracy is the answer to the question of how our tax dollars should be spent. If there's a consensus that we need certain public services, and we're going to have public employees provide fire services, police services, teaching, etc., it ought to be our elected representatives who ultimately make the final decision. So, let's talk about what happens with non-public safety. Non-public safety employees, we go through the same collective bargaining process, we go back and forth. If you reach impasse, there are certain steps that have to be followed. After that, it's called fact-finding. If fact-finding doesn't resolve the issues and you're still at impasse over wages, benefits, terms of employees, etc., at that point, the elected legislature can impose its final proposal. However, the public employee union has a right to go on strike. And if anybody here has had any experience with a strike, as you know, strikes are very disruptive, can occasionally result in violence. And if we're talking about essential public services like schools and public health care facilities and garbage pickup, the effect on the public can be immediate and dramatic. So again, you're going to hear that there have been very few strikes since the collective bargaining law went into effect. But every time we sit down with the refuse collection union or the teachers union, that threat of a strike hangs over your head and often results in unwise concessions being made. So one of the things that the new law does is that it bans public employee strikes. That was the law in Ohio until 1983 under a law called the Ferguson Act. Since 1983, non-public safety employees have had the right to strike. This would return, SB 5, issue 2 would return the law to pre-1983 to something similar to the Ferguson Act. Employees, of course, public employees could still withhold their labor through mass resignation, but they would not have the right to strike, set up picket lines, disrupt services, and expect to get their jobs back, which is the current system. 3 minutes? Okay. You'll see items 3, 4, and 5 on my handout deal with some areas in which the state legislature decided not only to reduce union collective bargaining power and restore the right of the state of elected representatives to make these final decisions, but also the state legislature decided that we have to have certain minimum standards around the state for what our collective bargaining agreement should look like. And when I say minimum standards, you think, well, minimum wage, is that what he's talking about? No. You might, from the union point of view, think of these as maximum standards, but it's the state legislature saying that as a matter of statewide policy, there are certain things that we want to add to the list of must-do for state and local government. And that includes a requirement that employees pay at least 15% toward their health insurance. It takes staffing and contracting out decisions off the table, and there are a few others. There are some other similar items. But finally, before my time is up, I want to talk for a minute about my item 6. This is something that the State House added as an amendment, which is an open shop provision. This was not in Senate Bill 5 when it was first passed. It was added by the House, and of course, you'll hear the unions say that, you know, this is evidence that the state legislature is all about breaking union power. This isn't about budget issues, and I understand that point of view. But I would also suggest to you that if unions are given an exclusive power of representation over employees in the workforce, then they ought not to be able to force those employees to pay dues to keep their jobs. I think it's a matter of principle and a matter of right, a human right or a personal right to be able to say, hey, if I've got to take a job where this union is going to decide for me what my terms of employment are going to be, and that's the way it works with exclusive representation, both currently and in the new system, then I ought to be able to decide for myself whether or not to pay dues to this organization. And of course, I make a choice. If I don't pay dues, I can't go to the union meetings and vote on the officers and vote on contract proposals, but at least I can save that part of my paycheck. At least I've had that freedom of choice, and I don't necessarily have to be forced to support and pay an organization that might not be promoting ideas, issues, and policies that I don't agree with. So I look forward to your questions later on, but thank you for your attention.
This is interesting for me in a couple different ways, because speaking to attorneys is something that I haven't done on this issue. A lot of the friends that I have are not attorneys, and when we go out to dinner at Wives, and I start to talk about what I do, everybody has to go get a drink. So I've had a lot of fun the last couple of months because people have actually been interested in what I do. So it's, you know, maybe someday you'll have your turn, the legislature will stick on whatever you do, and you'll be able to, you know, to fascinate people with your jobs. But interesting issues here, and interesting challenges actually that this bill brings up. And unfortunately, we're in a situation now where this is an up or down on a bill that I believe is very flawed, and I'm going to get into that, or no revisions, no modification whatsoever. Those are probably not very appetizing choices unless you're, you know, made up your mind as to what you think is appropriate, because you have nothing or something that perhaps is not good policy. So Maurice's comments at the beginning about if this is defeated, where do we go from here, I think is probably a pretty reasonable thing to be considering, and hopefully some of my comments tonight may help frame at least some of those issues for the future. I'd like to start out discussing collective bargaining with an understanding of why the law that we have now, that we've had for the last 27 years, why that law was created. Because I think that the new law is not taking into consideration the reasons that we have the current law. And without that understanding, without understanding what was going on in Ohio in the late 70s and early 80s, and why that law was created, this new law could have some very detrimental unintended consequences. So going back in Ohio to the 1970s, Gary mentioned the Ferguson Act. There was a law that said that strikes were illegal by public employees, severe penalties If you violate, you get fired. I mean, you're gone. You can't get your job back. Public employees, however, became more and more dissatisfied with their working conditions, and there were illegal strikes in the state of Ohio. And of particular note were illegal strikes by police and firefighters. The one that I'm most familiar with is in Cincinnati in 1979. There were 4 police officers that were murdered in a 10-month period of time in 1979. And after each one of those officers' deaths, the police went to city council and asked them to purchase bulletproof vests and higher caliber ammunition. And at each instance, city council said, well, let us think about it and we'll look at it. And the second death, the same response. The third death, the same response. And after the 4th death in 10 months, the police officers took their police cars en masse down to City Hall, parked hundreds of police cars all around City Hall, turned on the lights and siren, locked the doors, and threw all the keys in a box, and walked off the job. City of Toledo almost burned down. Firefighters walking off the job. Unfortunately, this happened so long ago that a lot of people don't remember it, but these public safety strikes that were occurring throughout the state of Ohio is what led to the creation of the collective bargaining law that was implemented in 1984. So we have, before collective bargaining, strikes are illegal. City councils get the final authority at the end of whatever if there is any negotiation. And we have rampant strikes, dozens of public safety strikes in the state of Ohio. We have had, since 1984, 0 strikes by public safety units, 1984 to the present. And my concern is that if we create a law, which I believe in effect mirrors the law that existed in Ohio before 1984, there will be some significant unintended consequences. So let me explain the process, because I have heard throughout this debate that the current process is a bad one, and that we need a balanced process, and that this new process under Senate Bill 5 creates the balanced process that the state needs. And so you sit down and you negotiate, and this is easier to do with the group of attorneys. I mean, I can get into a little more detail this than I normally would. But each party, before you negotiate, I'll sit down with my negotiating committee from the union that has been elected by the members of the union, and the city attorney, either outside counsel or law directors, will go to the city councils or the county commissioners, and they'll have a discussion about what do you guys want me to accomplish. I'll have the same discussion, maybe some prioritization of what's most important, what do you need, what can you live without, and you begin to negotiate written proposals, packages of proposals, and there's usually lots of meetings. At the end of that process, if you're kind of hitting a loggerhead, you can call a mediator. Everything that happens with the mediator is confidential, so you have the ability to perhaps put a little more on the table than you would if potentially it's going to be held up later on. So the mediator process can help you get to an agreement. If you can't work it out with the mediator, then you go to the fact finder. And there's a list of 7 or 8 criteria that the fact finder has to consider. Each party submits their offer simultaneously to the fact finder. This is someone that the State Employment Relations Board, they give each party 5 names. You each strike 2, so the one remaining is your fact finder. Fact finder has the ability to craft their own remedy on all of the outstanding issues. So in other words, Gary's example, the union wants 3, the city wants 1, fact finder can come back with 2, fact finder can come back with 1. Fact finder can do what they want to do. They can say that I'm going to do 1 effective in the middle of the year, whatever. And just as an aside, that example is one that, that's kind of an interesting 1 to 3%. Under Senate Bill 5, management could come in and say, we want a 10% pay cut. And this could happen in a time when we don't have economic problems in a particular city, okay? But that management thinks it's a good idea, they want to build a streetcar system, let's say, or they've got some other priority other than public safety that they want to pursue. And there's no question they've got money, but they want to pursue this. At the end of that negotiation, the union has no option to do other than what the city wants done. So back to where I was. So the fact finder comes back with their report. This is where I think the current law makes a lot of sense. If either party wants to reject that fact finder's report, you need to have a supermajority, or 3/5 of your membership, 3/5 of the members of city council, or 3/5 of the union membership actively vote no on that report. It's much more difficult for a union. I represent Cincinnati police, Cincinnati firefighters, about 1,000 members in those groups. So imagine you've got to get 60% of them coming out and actually voting no on a report. Because if you don't vote, it's considered a yes vote. Okay, so the legislature created a system where they want these reports to be accepted unless they're really flawed. Okay, much easier for a city council of 9, 7, or 3 county commissioners to vote no on that report than it is for a large union. If nobody rejects that report, you've got an agreement. Just like if at the negotiating table, you've got an agreement. And I would say a vast majority of my negotiations, we get agreement at the negotiating table. Okay, this is not, it's in everyone's best interest to get something done at the negotiating table, because there is risk to management and there's equal risk to labor if you go to fact-finding and conciliation. So if somebody does reject this fact-find report, you go to conciliation, binding arbitration. Binding arbitration is a little different than the fact-finder. One, it is binding, but it is subject to court appeal under 2711, just like any other arbitration decision would be. So it's not just if the guy's sleeping with someone or he's corrupt, if he exceeds his authority, okay? And I have been in court over conciliation awards, and they've been overturned in court. So there is an appeal process that is available to both parties under the current system. So you go to your conciliation hearing, you have to exchange your last best offer on each issue 5 days before that hearing. I don't know what the city's going to have in their last best offer. They don't know what I'm going to have. And the conciliator has to adopt one or the other last best offers. And why is that important? I think it's a good system because what it does is it forces both parties to their bottom line. In other words, if I want a 3% raise, the fact finder, let's say, has recommended a 2% raise. I don't know if the city's going to stay with their 1% raise. Are they going to go to 0? Are they going to be 1.5? Or where are they going to be at that conciliation? I don't know. If I ask for my 3, my chances of winning are significantly less than if I move down to 2 or 1.5, whatever. Okay, so both parties, because this process of that conciliator on item by item has to accept one or the other last best offer, is going to push people to the middle. Conciliator also can't award anything that would have economic ramifications that would be effective before the beginning of the next fiscal year. So in other words, the conciliator is appointed in January. Their award can not have economic effect until the next January. Why is that important? Because it takes into account the current budget of the employing agency and says, we're not going to do something that will affect you in your current fiscal year. Another, I think, very wise part of the current law. Current law also has a set of 7 or 8 criteria that the conciliator is to look at. So this is the process that we've had in Ohio since 1984. It gives both parties an equal opportunity to make their case. And when I'm in negotiations, I'm assessing my case on each issue that I'm bringing to the table. How do I look? External comparables. In other words, let's say police. Other police departments of similar size, similar geography, similar economic conditions. How do I look compared to them? Am I low? Am I high? Am I where I should be? How do I look internally? Internal comparables. The firefighters, the waste water people. How do I look compared to them? How do I look? How is the economy in the area that I am in? What kind of condition is the employer in? These are all factors that a fact finder and conciliator are going to look at. I can present written evidence. I can present testimony, oral testimony. I present information. The law requires a transcript to be made of this hearing. So this is all going on. The conciliator issues their report, and it is a binding mandate. All right. So what do we do? And another thing I think is important that Gary brought up about political influence and meddling. The State Employment Relations Board has a set of unfair labor practices that can be engaged in throughout the process, but under Revised Code 4117. And one of those is direct dealing by either party during the negotiation process with someone other than the duly appointed negotiating team of the other side. In other words, I can't, and my team cannot go and talk to City Council during that negotiation, because if they did, it's an unfair labor practice to do it. Likewise, the management team cannot go to the police officers and say, hey, you know what they came in the table with yesterday? Can you guys believe that? They can't do that either. That's direct dealing. It's illegal. So I would suggest that if management is concerned about that and it's going on, then file an unfair labor practice against the union. All right. But getting back to the process, so we have, this is the current process. The Columbus Dispatch did an article looking at this binding arbitration process. They looked at all the cases, 2009 and 2010, that went to binding arbitration. In those 2 years, there were thousands of negotiations that occurred. There were 20 cases in the state of Ohio that went to binding arbitration in 2 years. Of those 20, management prevailed in 10, and the unions prevailed in 10. The final offers on the wage increases were approximately 1% apart. Is this really busting the budget of the state of Ohio? I think that it's popular, and let's look at public employees, and let's focus here. But 20 in 2 years, and it seems pretty fair to me as far as how it's worked out. Let's compare that now to what would happen under the Issue 2 Senate Bill 5 process. You'd have negotiations, but at the beginning of those negotiations, you know that if you can't work it out, that the City Council, who's already directed their attorney as to what they want to accomplish in that negotiation, that the city is going to be able to impose their will. And so the question that I have, and I think Shannon Jones said it best, is that both parties have to have an equal opportunity to win or lose in order to have effective collective bargaining. I mean, if one party at the beginning of the negotiation knows that they can impose their will and get 100% of what they want, what motivation do they have to negotiate? And that's the system, that's the fundamental flaw with this law. And I think, Maurice brought up at the beginning, where can we work together? Where can we fix this? And a lot of the ads say, well, you should pay 15% for your health care. Well, state employees pay more than that already. Most jurisdictions pay somewhere in the neighborhood of 15%, but can we talk about that? Sure. You should pay 10% for your pension. Well, over 90% of the public employees already do that. And the only ones that don't have reached an agreement, usually management suggested agreement, that instead of giving you a wage increase this year, because it's going to be more expensive for us, would you guys accept us picking apart your pension? And the unions, at this point, I would say unwisely, agreed to it. Agreed to management's proposal. I mean, now, those unions that agreed to a pension pickup instead of a wage increase are going to get hammered under this bill. They should have said, no, we're not going to take that. Obviously, nobody knew that this was coming, but those unions that have negotiated, you don't just negotiate one benefit, it's a whole package. So wages and insurance, for instance, go together. Some of the groups I represent have said, we want to keep our health care contribution low, and we will take less in money in order to keep our health care low. Well, I would say to those people, you chose poorly under Senate Bill 5, because you're going to get taken here, because you're going to have to pay 15%. And as management can come in and say, well, we remember that you got smaller wage increases to keep that health insurance low, so we're going to give you a big raise to make up for it. Maybe, maybe not, right? But negotiation, what this bill is doing is it's cherry picking certain things and saying, you got to do this, you got to pay this, you got to do this. And those are minimums, by the way, okay? And remember, the overall arching problem here is they're minimums, and there is nothing to stop a city council to say, 15% health care? How about 80%? You're going to pay 80%. No, union says our proposal is we pay 15%, or maybe even 20%. Okay, well, let's take this to a hearing. And the city attorney, who's been directed to get 80%, comes in and argues, we really think you should adopt 80%. And I come in and say, look, 20%, I mean, look at all the comparables. All right, well, what's the city council going to do when they go in the back room and decide? You know, who's going to win 10 out of 10 cases here? And is this going to return Ohio to pre-1984? What is different about this system than what existed in Ohio before 1984? What is different? And I would submit there's not much different. Probably the biggest difference is that there's been 27 years of labor peace and 27 years of unions being accustomed to having a seat at the table and having an equal opportunity to present their case to a neutral third party. You know, is that so terrible to have the ability to have a third party weigh the merits of the arguments on both sides? Some of the other information that I wanted to share with you on this, and this is interesting about this binding arbitration piece. There was about 5 years of litigation over whether this binding arbitration was constitutional or not. 1989, the Ohio Supreme Court finally resolves the matter and says it is constitutional. But here's a quote from their decision. The General Assembly wisely recognized, however, that without the right to strike, safety forces would have little strength to bring to the bargaining table. To compensate, the legislature provided for binding arbitration so that members of safety forces and their employer may obtain independent, binding review of their contract proposals. The decision of the conciliator is binding on both parties, whatever that decision may be. For safety forces, Revised Code 4117-14I is the heart of the Act. Absent binding conciliation, the bargaining rights of safety forces would become virtually useless. And that's exactly what we're doing here under Senate Bill 5. So what are some of the other fundamental problems with this law? First of all, we have this fair share piece, and Gary touched on that a little bit. This has nothing to do with the budget of the state. You know, this whole thing came up with, we've got an $8 billion deficit and we need to fix it, and we all have to share in the sacrifice. Forget the fact that the legislatures refused to take any sacrifice or pay cuts. That was actually in the budget bill, and they took it out. Okay, so we all need to share in the sacrifice except the people writing this bill. And so the people in the middle are going to share with themselves the sacrifice. But you're also not going to be able to collect fair share dues, fair share fees from people who are part of your bargaining unit. Now, fair share fees are different than union dues. For those of you that don't do this kind of work, a fair share fee is that portion of the dues that's attributable to negotiating your labor agreement and administering that labor agreement, and that's it. Union dues include that fee, that amount, but also any political or ideological stuff that the union wants to get into. If you don't want to be a member of the union, you don't have to pay for anything other than that portion of the dues that go toward administering and negotiating that contract. And you know, everything I've heard from Gary is the unions have done a hell of a good job of negotiating these contracts. I mean, you know, they've gotten everything that you could possibly ask for. Why wouldn't people at least be willing to pay that part that the union's done such a great job of fleecing the cities, right? I mean, my gosh, can't you at least pay that part of your dues? And so this bill makes that illegal. Anybody that doesn't want to be a member of the union cannot be forced to pay anything. Well, what's the effect of that? It's not going to save the city any money. All that is aimed at is hurting the unions. There's another part of the bill that says that the cities are, it's illegal for them to payroll deduct union dues from those that want to have the union dues. What's the effect of that? The union's going to have to walk around all 1,000 members every month and get them to give them a check. Is that, I mean, how is that saving money for the employer? This bill is full of things like that, which are designed not for Ohio, not to bring jobs to Ohio, but to harm unions in looking ahead to the 2012 presidential election, right? And that's just not appropriate for a bill that's being touted as something we need to make Ohio better. So anyway, I look forward to your questions, comments, but a lot of management groups have said that this bill is overreaching. It goes too far. It will cause more problems than do good. And these aren't just unions. I've got lots of sheriffs that say, I don't like this bill. I don't like it. It's not going to help my organization. The Ohio Association of Chiefs of Police has said it. OPELRA, which is the management group, gave a huge 15-page position paper on this. It said on this 15% on the health care, take that out. Let local governments do that. Don't impose that. One size fits all. It's not good for us. 10% pension pickup, don't do that. Take it out. And they didn't do any of it. And so we're stuck with a choice of overreaching, not good public policy, or nothing. Neither of which are good choices, but unfortunately that's the situation. I would urge you on this legislation to vote no. Thank you.
Well, I've been ordered to keep my response to 2 minutes, so I'll talk fast, but we do want time for questions. I'm going to have to go back and check SB 5, but I think it does allow for payroll deduction of union dues or fees on a voluntary basis. But I won't say that for sure until I go back and look. There is this distinction between fair share fees, which can be mandatory, and union dues, which may not be mandatory under the current system. But the unions provide the accounting for the difference, and typically you'll find that the fair share fee is, I don't know, Steve, you can correct me if I'm wrong, is it usually 95 and 98% of the dues?
Depends on the union.
Okay, but it's usually pretty close to the 100% figure. And if an employee wants to challenge that, it's a very expensive and difficult process. As far as city council's always going along with what the city manager comes up with, that's just not accurate. And recent experience in Cincinnati bears this out with our safety forces. The city manager, dealing with this terrible budget deficit, is recommending cutbacks in the safety forces, and a council majority has blocked that and said, no, we're not going to do that. We want fully staffed police forces. So when these issues see the public light of day, city manager's recommendations don't necessarily get adopted. Now, the city manager may be following the mayor's direction, but we don't have an all-powerful mayor in Cincinnati, and so we have a council majority that right now disagrees with the city manager. As far as the arbitration system pushing people to the middle, what has actually happened is that it has had a ratcheting effect, and so what has happened is that the negotiations result in management proposals for expensive union contracts and union demands for more expensive union contracts, and maybe they end up somewhere in between those, but the overall effect on our budget, in my view, has been horrendous. And as far as, one last point, as far as the right to appeal to court, if an arbitrator exceeds his authority, that almost never happens, and it's very, very difficult to prove. It would have to be something obvious. Steve accurately described the system where you've got the 1% and the 3%. The arbitrator is supposed to choose between the two. If he comes back with a decision and says 0 or 2 or 4, then he's exceeded his authority. But that's obvious, and obviously the arbitrators who do this know they're supposed to pick between 1% and 3%. But the bottom line here is the bottom line. The overall effect of the collective bargaining law since 1983 has, in my view, been a disaster for state and local budgets. We need to do something to fix it. SB 5 isn't 100% absolutely perfect. I could have written parts of it a bit differently, but it will be a vast improvement over the current system. Thank you very much.
Yeah, you know, I don't sit in on the management side of this as far as how they develop their proposals, but David Pepper, who's done some of these, was a county commissioner in Hamilton County, and he explained the process where their attorneys come to the county commissioners, and they sit down and they have a discussion. The county commissioners tell them, go do this in negotiations, all right? So they provide direction for negotiations. What Gary's talking about is an internal debate, not a part of negotiation, where city manager says something, council says something else. Who's going to win that? Council's going to win it because they hire and fire the city manager, or indirectly through the mayor, I suppose, now in Cincinnati. But let me just get back to some of these parts of this bill that I think are just so unfair. The current system, you get a list of criteria to consider. The conciliator's got a list. And actually, there were changes to that list of criteria in the Senate Bill 5. At conciliation, there's no list. There's no criteria for council to consider. They can consider whatever they want, okay? The current system, the neutral third party has to adopt on an issue by issue, one party's or the other. Under this new system, he's got to take it all or nothing. So he can't even pick one of the union's proposals. He's got to either pick all the city's proposals or all the union's proposals. Under the current system, a contract can be for up to 3 years. Under the new system, it must be a 3-year contract. How does that take into consideration the local economy? Under the current system, the conciliator, it's subject to this appeal to court, just like it is for arbitration. You probably work with that. New system, there's no appeal to court, except there's one way you can appeal, not to court, but you can appeal, the people can put a referendum on. So the only way to get a referendum on is if the decision of the legislative body is going to require additional revenue. And if it does, then, now 3-year contract, right? What 3-year contract isn't going to require additional revenue? I mean, it's going to have to be a pretty bad contract, right? But that's all right, we can do that if we want to. So if it does not require additional revenue, there is no ability even to request a referendum of the voters. So the unions don't even have, if the unions say, foul, we got a raw deal here. They took 40% away in our pay, they're making us pay 90% on the health care. The law says you can't take that to the voters. If it requires a nickel more in revenue, voters can decide whether they like that decision or not. Is that fair? That's what's in this law. The old system, we talked about appeals to the court. The old system, we've got voter review. The old system did not provide, this new system has a requirement for a hearing to be held before the public. And I think some people have taken that to mean that the public's going to be able to come in there and tell the legislators, you got to do this, you got to do that. Well, it doesn't say that. It just says that a hearing will be held that's open to the public. So the public doesn't have any more say in what's going to happen to this thing. It is a law that's not just slanted in favor of management, but there's not even a fair process at all. And if the local legislative authority has the foolhardiness to actually want to do something for their unions, then this law's got all kinds of safeguards that says you can't do it. You can't do it. So it's just not, it's not a fair law. It's not good policy, overreaching. It's not good for a lot.
We've got time for a few questions, and I certainly have 1 or 2 of my own, but before I do that, I'd like to give any of you a chance, and I will jump in right away if you don't take the opportunity. So does anybody here have a question for either Gary or Stephen before I might do that? Yes, Josh.
My question is for our labor attorney.
Well, we're both labor attorneys. Management in union or management?
Union.
Yeah, so go ahead.
Federal employees don't have unions. The public sector unions make up less than 6% of Ohio's workforce. You know, and teachers are important, and firefighters are important, and police are important, but other employees are important too, but they don't have collective bargaining. So what's so special about this small group of people where they deserve this, and that if they don't get to bargain, then they're getting screwed over, and all they're asking for is a third party? What's so special about this particular group where they get something that 95% of the rest of the public doesn't get?
Okay. First of all, I'm going to break that into two parts. One, in Ohio, private sector employees can collectively bargain. They can form unions, and they have the right to go on strike. So they do have that right. So it's not 6% versus 94%. And under this new Senate Bill 5, public safety can't strike because they haven't been able to, and Gary rightfully said, because the legislator said, we can't have these people go on strike. I mean, we got to come up with some process. I just question whether this process is one that's going to work. But the non-safety forces can go on strike, and that's a similar process, if you will, to the private sector. Your other part of your question, though, was federal employees, and that federal public sector employees do not have collective bargaining rights, and that is accurate in most cases. And you know, I guess I look at it as I'm not sure how much I want to model Ohio and the future of Ohio and how our federal government's working. I mean, last time I looked, they haven't been a terribly good example of fiscal responsibility and how to control deficits and how to do things. So, you know, if we want to start looking at bringing in the federal government as our model in Ohio, I don't think anybody in this room is going to go for that. I certainly would. So, you know, yeah, that's true. That's part of what they do in Washington, but that's one part of a lot of things they do in Washington. I don't think we want to adopt Washington in Ohio.
May I comment on that?
Sure.
Yeah. Let me clarify a bit about federal employees. Federal public safety employees, for the most part, do not have the right to collectively bargain at all. We're talking about our military, FBI, Secret Service, U.S. Marshals, etc. Recently, the TSA, I don't know if we want to think of TSA as public safety, there may be public annoyance, but they are there for safety reasons and security reasons. They were recently given the right to collectively bargain like many other federal employees. But the federal employees that have the right to collectively bargain do not have the right to strike. None of them have the right to strike. In fact, remember, the traffic controllers, well, some of you are too young to remember this, but back in the early 80s, the traffic controllers went out on strike, and President Reagan fired them because their strike was illegal. So they were fired, and new traffic controllers were hired. And the newly hired traffic controllers have organized into a union. They collectively bargain, but again, no right to strike, and no third party comes in and says, this is what your pay is going to be, this is what your benefits are going to be. Essentially, there's a process of collective bargaining to discuss certain terms of employment that are written down into a contract. There are steps that have to be followed. There is a right to file grievances and unfair labor practices, but ultimately, Congress makes the final decision about pay, benefits, and terms of employment. And as far as not modeling the federal government, remember what I said, personnel costs are not the issue with the federal deficit. And federal government employees under the current system, under civil service, under the federal collective bargaining for those that have those rights, works perfectly well for federal employees. And in fact, the way to think about this is what SB 5 and Issue 2 does is it makes our state and local government collective bargaining system very much like the federal system.
Others? Yes, Eric.
How is the arbitrator picked in the binding arbitration? And that's the first question. And number two, do private employees have any type of binding arbitration as compared to public employees? For either of you who know.
Could you repeat the first question again?
How are the arbitrators chosen for the binding arbitration?
Yes, there is a panel of professional arbitrators and we have a state agency called the State Employee Relations Board, SERB for short, and they basically they keep the panel, and when it's time for arbitration or conciliation, you write away for names and then you select from the list. But these are professional arbitrators who do this for a living, typically in both the public and the private sector, and they're the decision makers. Now let me get it. Your second question is very interesting, and you know, the short answer is no. In the private sector, there is, you'll find under union contracts, you can arbitrate issues involving disputes over the meaning and application of that contract. When the contract expires, you negotiate for a new contract, and you either reach agreement or you reach impasse. If you reach impasse, the private employer has a legal right, as long as he is bargaining in good faith, to implement the final proposal. The union has the right to either, well, accept that and work under those new terms or go on strike. During that strike, the private employer has the right to stop its operations, or it has the right to continue those operations, and may do so with temporary replacements, union employees who choose to cross the picket line, and again, if they bargain in good faith, they can hire permanent replacements. And permanently replacing a striker doesn't mean the striker is fired. It means that when the striker says, we're done with our strike, we're tired of walking the picket line, we're ready to come back to work, then that striker has to wait until there's an opening for which he's qualified. So two interesting sidelights to the question you just asked. Some of you may have heard of some legislation proposed by organized labor called EFCA, the Employee Free Choice Act. And what got the most publicity with EFCA was the provision that said that going forward, unions would be able to organize by getting employees to sign individual cards that say, we want to be represented, so on and so forth. So there would be no more secret ballot elections, unless the union consented to a secret ballot election, and they never would. All they have to do is go employee by employee, get these cards signed. Once they get 50% plus one, the union is in. Okay, so it makes it easier to organize. But there's another part of EFCA that didn't get as much attention, but that was frankly even more dangerous to our economy and to the business community, and that's the binding arbitration provision. And what this provision said is that if a newly organized union can't get a contract within 120 days, the parties have to pick the neutral arbitrator, you have a hearing, and that neutral arbitrator writes the contract. And I'm telling you that that would be a disaster for the American economy. You think we have competitive problems now? Imagine if neutral arbitrators start writing our union contracts in the private sector. Now, circling back to what's going to happen after this election. If we go back to the current law, one of the things that's going to have to be clarified is whether or not under the current law, for those employees that have the right to strike, do public employers have a right to permanently replace them? That is really untested. But if we're going to go back to the current law, given the budget crunch that we're under, if SB 5 is shattered by this referendum, its shards are going to drift down over the entire state. And what's going to happen at a local level is that there are going to be many SB 5 battles here, there, and everywhere as local government tries to get their budget under control. Remember that the Kasich budget cut way back on the local government fund. Think about what's going on with the school districts and all the pressure they're under and how difficult it is to get tax levies passed. Well, we're going to have very difficult negotiations with municipal employees, with social service employees, with teachers. And if and when they go out on strike, public employers are going to have to ask themselves, what's the state of the law? Should we hire permanent replacements? And I would posit to you that one of the things that has to happen with the legislature, if this referendum fails, is that we need to look at that particular issue, and we need an amendment to the current law if we don't get SB 5 in place, that clarifies and confirms that just as in the private sector, public sector employees who strike can be permanently replaced.
Yeah, gonna just add on to some of the things that Gary was talking about here. With the police and fire, it's different. Than there is no private sector comparison to police and fire jobs, so you really can't, and that's part of the problem with a lot of the studies that have been done, that the school teacher here, the private sector versus the school teacher in the public sector, this one makes more or less. There are no private sector police officers or firefighters, so these comparisons of they're paid too much really go out the window when you're trying to compare private and public sector. And you know, realistically, a police officer or firefighter's job has a different component than certainly my job and a lot of other jobs, where you know, I go to work in the morning and say goodbye to my wife if she's awake, and you know, I'm going to come home that night. I'm 99% sure I'm going to be home. Police officer and firefighter probably coming home, but you know, maybe not. And is that important? I mean, is that something that should be taken into consideration when your compensation's looked at? I wouldn't want to do that job. I know a lot of them. I know how they work. I wouldn't want to have that job. So, you know, that's part of this. Well, we can't go on strike. So there is a reason, and I think it's a very valid reason, to have a process for police officers and firefighters, because it's critical that they not walk off the job. And keep in mind the Cincinnati experience. They didn't walk off over money, over health insurance. They walked off because they needed bulletproof vests. And you know, people who talk about SB 5 say, well, we put that back in. We put it back in that you can negotiate over safety equipment. Yeah, it's in the bill. You can. I mean, if they were smart, they would have said you can negotiate over anything. You can negotiate over staffing. You can negotiate over sick leave. Because at the end of the day, who cares? We can do what we want to do, right? I mean, why even say we're not going to let you negotiate over this? We can do what we want. So to say we put it back in the bill so you can negotiate over is really, it's a sham, because it doesn't mean anything. They have no ability, management has no ability to lose this process if they impose their will. Then we talk about the status of cities and counties and what's going on. First of all, there have been huge concessions since the beginning of this downturn in the economy by public sector unions. And I'm not just talking about pay freezes. I'm talking about true hard give-backs of, we're not going to take this, we're going to give back 5% of our salary. Cincinnati police officers gave back over $1 million in 2009. City came and sat down with them and said, let's figure out a way to make this work. Here's our books, open them up. We need your help. And they came up with a mutually agreeable package of concessions. And they did it together. Now, it works, okay? Toledo. When we heard from the Toledo mayor about, you know, his losing his job and so forth, he lost his job before the current collective bargaining law was put in place. So we really can't blame this law for the mayor's loss of his job. But here's the other part of Toledo that's so important, because Toledo ran into this situation. They had a huge budget problem. They paid for their employees' pension. They had agreed to that pension pickup in the past. The employees did not pay very much for their health care. And the mayor went to the unions and said, I need your help. I want you, well, he kind of said, we're not going to pay for your pension pickup anymore, and you're going to pay more for your health care. And the response from some of the unions was, we get a contract, right? And the mayor, at the end of the day, worked out deals with a lot of the unions, but one of them said, no, I'm not going to do it. They had a contract. And you think to yourself, well, under this current process, we're done. We're going to go bankrupt, right? No. Current law says that if there are exigent circumstances, that's the phrase, exigent circumstances, that were not known at the time of the negotiation of that contract, management has the right to trump that contract. And the mayor of Toledo said, you are paying more for your health care, and we're not picking up your pension anymore. Union held up the contract. The mayor said, I'm doing it. Union filed an unfair labor practice at the state board, said, can't do it, we got a contract. State board affirms the mayor's decision. This isn't SB 5, this is current collective bargaining law. So, you know, to say that we're hamstrung, we have no ability to do anything. The law that we have right now, it's been around a while, and it does work. Other issues on what's going on with the current process. This bill has a lot of pieces to it that, particularly related to teachers, that are going to be implemented, whether or not SB 5 passes a referendum or not. The budget bill contained pay for, performance pay for teachers. Layoffs cannot be based exclusively on seniority. A new evaluation system for teachers. This is the law today. You do not need Senate Bill 5 to get those things. It's in the budget bill. It's not referendum. It's going on right now. So if the anger is at teachers, all right, you got it. It's in the law. And SB 5 won't change that. In fact, some of the proponents of SB 5 have said that the way the budget bill is written and the way SB 5 is written, they're a little different, and actually could create a problem because we're not sure which one's going to prevail. You know, this bill was rushed through the legislature in about a month and a half. 300-400-page bill that had huge amendments to it, and it's got some problems on this. Even on this 15% health care issue, there's one part of the bill that says state employees must pay a minimum of 15% of the cost of premiums. There's another part that says everyone other than state employees must pay at least 15% of the cost of the health care. Huh? Why should the standard for the state employees be different than the rest? It shouldn't, but nobody caught it. So you're stuck with a flawed bill that overreaches. It calls for transparency in 6 different places. You got to open the doors. Nobody knows what's going on in these negotiations. We don't get to see anything. The public's got to be in there. We need to have a seat at the table and see what's going on. Well, I'm not opposed to that. I think it's a good idea. I think management should be more afraid of the public seeing what goes on there than me, because I think I take very reasonable positions. And I prevail sometimes because management is taking an extremely unreasonable position. I'm not afraid of a third-party neutral looking at the merits of both sides' argument. I have no problem with that. So let's start with transparency. I mean, until everybody understands how this process works and has had an opportunity to watch it and see it, is it really wise to just throw the whole thing out? Because that's what this bill does. I mean, there's an acknowledgement in the bill that we don't know how this works. So shouldn't we find out how it works and consider the reason this bill was created before we throw it away? And that's really what you have to decide. I would urge you to vote no on this bill. Thank you.
We're just about out of time. If anybody else has one more question, it's kind of a light.
I've heard some people claim that the real distorting effect in public sector as opposed to private is that you've got a mayor who's not using his own money, it's tax money, it's not shareholders, and across the table are people who got him elected and run his phone banks. If that's true, wherever there's power, then is it possible that one, the sky won't fall because of these changes, on the other hand, it won't help a lot either, and that the effect on both sides is greatly exaggerated because it's the politics of other people's money that's driving this whole thing, and a lot of this is beside the point. Either side?
I would like you both to answer that in about a minute, and I would like to tap on that. That is exactly the issue I was wondering about as you were both speaking. You both focused on the binding arbitration issue so much, and as Gary was talking, I was thinking to myself, as a taxpayer, he's saying, let democracy work. And within our republic, one feature is democracy, and a feature of democracy is the collective action problem, whereby the unions do have tremendous power.
Point of order, I was shorter than you, Maurice.
It's true. It's true. Well, okay. Point. So it's the same, two sides of the same coin. Democracy doesn't really help us that much, does it? For me as a taxpayer versus the binding arbitration. But then the same question is put to Mr. Lazarus. With democracy being so much in favor of collectivized interests as against diffused interests of taxpayers, don't you already have a tremendous amount of leverage even without the binding arbitration? So that's Mr. Carney's question, and simply everybody has said it, but not in their own way, so I said it my own way too, now each of you.
Yeah, let me, you know, I think the answer to your question has to be, it all depends, because I have some local jurisdictions, county commissioners, that run very well and are not dysfunctional and make good decisions. From my experience, those are generally the ones that don't like this law because they have worked collaboratively with their employees and it's worked for them. The ones that are dysfunctional are the ones that really like this law. That's my personal experience, because they don't like the idea of having to sit down with their employees and actually work through a problem and struggle with it and get their hands dirty. They want to just say, we're doing this, whether it makes sense or not. And keep in mind, you know, the best labor management relations are the ones where you work together to solve a problem. And if one side doesn't have anything to lose, there's not a lot of incentive, unless you're a good manager, there's not a lot of incentive to work together. If you're a bad manager, issue 2 is going to be a nightmare for your jurisdiction. Because the employees won't. They'll just say, fine, you're going to do it. Doesn't make any sense. It's going to cost you more overtime. You're going to have to hire 5 more people. But go ahead, do it, you know? So you won't have creative solutions. In Cincinnati, the city entered into a collaborative agreement with the African American community. The FOP had an equal seat at the table, and this thing has been wonderful. 10 years ago in Cincinnati, the police officers were hated by the minority community, despised. They agreed to be an equal party in this collaborative, and they had an equal seat and an equal voice, and they created a model for the United States, to the extent that about 6 months ago there were proposals to bring the Hamilton County Sheriffs in to run the patrol function in the city of Cincinnati, and the African American community was up in arms over it. We don't want them. We want our Cincinnati police because they are the best trained and they're the best for us. Now that doesn't happen from a thumb on you, you know, you're going to do what I say. So it all depends on the jurisdiction of what kind of relationship they have. Cincinnati right now, I don't have the local Columbus issues, but 62% of the people in Cincinnati don't build this streetcar. We don't want it. We want nothing to do with it. Don't do it. Well, council's going ahead and doing it. So, you know, should the employees, at the end of the day, in essence, trust the elected officials to do the right thing? And in my experience in Cincinnati, I think it would be extremely unwise to give that authority to city council. And ironically, I find most of the people on the other side of this debate to be equally frightened of a Cincinnati city council having 100% authority. I think, are you kidding me? I mean, let them make all the decisions? Even the politicians in Columbus, when they wrote this bill, really don't trust your local officials because they put all kinds of things in there that as long as you make the right decisions, then you have authority. If you make the wrong ones, we're going to let the taxpayers decide, right? Is that really giving your local authority, you're giving control over to the local governments? It's not, and it's imposed, you got to do 15% here, you got to do 10% here, you can't do more than that. They're not giving your local officials authority to make these decisions locally. They're telling them it's going to be this way. It can be a lot worse on the employees if you want it to be, but it will not be better. That is not trusting your local politicians. Columbus doesn't even trust them.
Well, I want to go back to what I said about 2 big bites at the apple. And under the current system, the unions have all the political influence that they have, which is substantial. And then if they don't get what they want through the political influence they have, this additional power under the current law for public safety, that's the power to have an unelected, unaccountable third-party arbitrator who lives 200 miles away write the contract to make the final decision for the citizens and the taxpayers. For non-public safety, of course, it's the right to strike and disrupt essential public services. So what Steve describes as the dysfunctional legislators, in many cases, what he describes as dysfunctional, I think of as legislators who put the citizens and the taxpayers first and the employees second. And I think that's the way it should be. And that doesn't mean you treat your employees with anything other than civility and respect. It doesn't mean you don't listen to their good ideas. It doesn't mean that you don't pay them decently and provide good benefits, just as the private sector employers do. 94%, 93% of all employees in the private sector now are non-union. It doesn't mean that they all make minimum wage with no health insurance. Why? Because the market requires that if you want decent employees to provide good services, you have to pay a decent wage, a decent benefit, which is what the market will bear. So the answer to your question is that, in my view, SB 5 is necessary to get our budget under control. It's not sufficient. We still have to keep our eye on our legislators, and in fact, I'll plant the seed right now. I suggest that what's needed in this state is a taxpayers union. We have the seeds of that with different groups, taxpayers groups around the state, Tea Party groups, et cetera, and I think that they should coalesce into a taxpayers union to, in a way, collectively bargain for spending packages on personnel costs and other costs that have the taxpayers and the citizens in mind as we move forward. Thank you.
Whether that taxpayers union will be subject to binding arbitration will be the subject of our next meeting together. So that is all the time we have. We are out of space. Thank you all for coming tonight. Very interesting.